system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
Good morning, all. We continue in the trial of State of West Virginia versus Natalie Cochran, and it is case number 23-F-343K. All parties are present, including the defendant. Are there matters that we need to take up at this time out of the presence of the jury?
That's for the state, Your Honor. Thank you.
No, Your Honor. Thank you.
I would ask counsel and the defendant to come up and let's check over the exhibits to make sure that we have the right ones that have been admitted. I'll ask the clerk to help come forward and let's double check to make sure we have no problems. Okay. 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 You've confirmed that?
We don't think there's any mistakes in the exhibit list at all. We think that that's correct.
Okay. And you folks?
I agree. I concur. I don't think there are any mistakes there or anything that would catch our eyes. I mean, there's one thing that Mr. Selden, I think.
I brought that up and that's been cleared up.
Okay.
So we're squared away. Okay, I just wanted to double check. Thank you.
Just briefly go over what your plan is with the alternates. I was thinking you just brought them back for today.
Yeah.
Make sure that 12 of them showed up. I wasn't. And then you'll give your standard.
Yeah, yeah,
Read anything up.
yeah.
You confuse people.
Well, sometimes I confuse myself. Let me explain the situation with the alternates. You never know when a regular juror is going to get sick or have a problem with a relative or something come up. And that's why I had the alternates come back today, and I'm going to excuse them. I thought about the possibility of keeping them in case we have to do a mercy trial, but I don't think that that would be appropriate because they won't engage in the regular deliberations. So we're going to go ahead and excuse them. That they have told the bailiff that they want to stay. We have a very good jury that's extremely interested in the proceedings. They're not grumpy, they're not complaining, and they are fulfilling their civic duty. So we can go forward and hopefully we'll have the regular jurors, less the alternates shortly. Anything, Mr. Victor?
My envision, Your Honor, is that if, and I'm saying if, there is indeed a mercy phase, and one of the jurors gets ill or something should happen to a juror during the mercy phase, then the mercy phase cannot be decided by 11 jurors.
This is true. That's why I contemplated the possibility of holding them, but keep in mind they will not engage in the regular deliberations, which may or may not cause us any problems. And the others will be ahead of the game in that regard. And I'm not sure that it would be entirely appropriate to use them later if they have not engaged in the rendering of the verdict. Now we can impanel a new jury simply for the mercy phase. I don't think that's the best idea. I would prefer to use our regular jury that's familiar with the case, because if we impanel a new jury, and all of this is contingent upon a guilty verdict, of course, but if we impanel a new jury, we've got a new trial. We have to cover a lot of ground.
I think the name is Jennings. Is that State v. Jennings that said if and we're way ahead of this, but just talking about
right.
If there is not a unanimous verdict, then you redo the penalty phase with a different verdict, different jury. That's really what we're talking about here. So I think the court could take the two alternates, instruct them as to what not to do until they're fully released, and then if you need an alternate at either phase, they're available.
And they can be contacted. The only issue is that if they want to stay here, they cannot be exposed to any
well, and
outside
they do
influence.
want to stay here. They've told the bailiff that they want to stay, and that's why. And of course, I can kick them out and tell them to run like turkeys home. But you know,
the court's already indicated they can't participate in the deliberative phase.
Right.
A need for
they want to.
Well,
yeah.
They would, of course, have to be isolated from any potential outside influence, and I think that can probably be done. And
Well, let me ask this, and we're way ahead of proceedings, but in the event there is a guilty verdict, a first-degree murder, I would envision going straight into the mercy phase, if not this afternoon or whenever the verdict is rendered, at least tomorrow or Friday. Are you folks contemplating coming back in 30 days? Or
The state believes that the court's procedure as stated is correct. There would be a verdict, timeout to get organized, and then proceed.
I agree, Your Honor.
Okay. And could you folks be ready as early as this afternoon, if need be, if we have to go into that phase?
Mr. Selden will.
Your Honor,
enlighten the court.
we've anticipated some of these problems. We would need at least 2 hours to get together our witnesses at a minimum.
Well, 2 hours would be fair. I don't have any problem with that. I just don't want an extensive delay because it's unfair to the jury and it's unfair to the judge. But again, we're talking about possibilities, and we don't know what will develop, obviously. But is it the suggestion then that I hold over the alternates in case we need them for a mini trial?
No,
The state would suggest that the court follow its standard procedure, instruct them, turn them loose to wherever they want to go.
Just release them.
I think so. I mean,
Okay.
that's what the court's done in the past.
That's what I've always done. But I know that Judge Hutchison, on several occasions, would keep the alternates.
I know.
And
But-
they would moan and groan about it.
As well they should. It seems you would get the benefit of their availability as an alternate while not making them just sit around in an isolated room in the courthouse.
Yeah.
Your Honor, I need to backtrack for just a moment.
Okay.
I stated to the court we would need at least 2 hours. Unfortunately, we're anticipating calling certain witnesses, and they would need not 24 hours notice, but they would not be available the same day. They would have to be contacted for the next day.
Okay. Well, let's see how it goes. We need to cross that bridge when we come to it. This is what I have decided to do. I'm going to release the alternate jurors outright. I think it's unfair to keep them, and we'll deal with the situation. Hopefully, we'll have 12 that will continue to participate if we need them. If we don't, we'll just have to impanel a new jury. It's rolling the dice.
If that's the court's decision, that's it. But this court has sent jurors home with instructions, or sent them wherever they want to go with instructions, and they're still available. You could inquire if their service is needed as to whether they've fulfilled the court's instructions, and that way, in the event that we're short, we don't have to start this all over again.
Your Honor, on behalf of the defense, I would object to that. There's been a possibility of jury contamination all through this case. We discussed it in depth. I believe these jurors, once the alternates, once they're released, they're going to feel like, okay, we're not on the jury anymore. We can discuss this, etc. I think there's just too much risk of contamination.
Well, that's my fear too, and I'm just going to follow the normal course of conduct, and I'm going to release the alternates, and we will see what happens thereafter. All right, are we ready for the jury?
Yes, sir.
yes, sir.
Bring in the jury bailiff. And one thing I'm thinking about, this is a really good jury. We haven't had any problems except at the very outset. They've been here on time, and they are prompt, and I've been watching them. They've been listening to the evidence carefully, and so I have confidence in these folks. And I got them sausage biscuits this morning too. That's why they want to. That's why they want to stay. Good morning, ladies and gentlemen of the jury. How are you all doing? I understand you're getting along very well from what the bailiff reports, and he says that you are happy and agreeable with each other, which is always pleasing to the presiding judge. We have reached almost the very end of this trial. This is the sixth and final stage of the trial. And as I explained to you yesterday evening, this will be the deliberation phase where you will retire to your jury room to deliberate on your verdict. And this will be the first time that you can fully and freely discuss the case, because I've been mean to you all along. I haven't been able to let you do any discussions, and I know you've been dying to talk about the case among your fellow jurors, but I haven't let you do it, and I've been like a broken record telling you not to talk among yourselves or with anyone else about the case. Before I send you into the jury room, I have to release the alternate jurors, and you folks have been just as wonderful as anyone else, and you have come and attended, and you have done everything required of you. Of course, your job would be to fill in for a regular juror if somebody got sick or someone had an accident or for whatever reason couldn't continue to serve. Then we would energize the alternate juror or jurors, and they would become regular jurors. And you saw this happen once before at the start of this case. So Haley Austin and Karen Buckland, where are you folks are the alternate jurors. And let me explain the situation. You can hang around if you want to, and you can wait and see what the verdict is in this case, since you've got a vested interest in it. You can run like turkeys home and watch The Price is Right and some of the other shows on TV. And you can call up here if you are curious, and call Judge Polling's office. This is his courtroom now, and he will tell you, or his secretary will tell you the verdict. So you're free to do that. Now, lots of people will want to talk to you, and obviously your family members will want to ask you questions about this trial, and you're free to talk to them about it. And you're free to watch accounts about the trial. I'm speaking to the alternates. You may have other sources, streaming sources, that will want to interview you, and that's entirely up to you. You don't have to speak to anyone. If someone would approach you and want to have you do a survey or even appear on camera, it's up to you. And if you don't feel comfortable with that, you can say no. I don't want to talk. If you do feel comfortable, you can, and I'll give you my permission to do so. And I don't have anything else to tell the two alternates, Ms. Except my sincerest thanks for coming and participating, and I'm sorry that you weren't able to finish things out and continue by deliberating on the verdict. So now, Ms. free to go with the bailiff to the jury room and to depart or wait on the premises as you wish. Thank you very much. Thank you. Thank you. Now the business is at hand for the rest of you folks. You will, as I say, go to your jury room to start your deliberations. And the first thing that you should do is to select a jury four-person. And you note that I say four-person instead of the incorrect and outdated term of four-man, because obviously it can be a for woman or for man. It's a for person. Now that person's job will not be any heightened. You won't have a heightened vote or a more important vote than anyone else, but you will see that the deliberations are carried out in a proper and orderly fashion, and most importantly, once a verdict is reached, you will sign as foreperson of the jury the verdict form. And we have worked very diligently to make this verdict form as understandable and simple as possible. It's 2 pages. I'm going to give it to you, obviously, put it on the very top of the exhibits and the documents that we send in with you. And you may wish to pass this around initially so you can see it. It will help focus your discussions, perhaps. When you reach a verdict, you should turn on the light. The bailiff will show you the switch, and the bailiff will come in and gather you up and bring you back into the courtroom. The foreperson should hang on to this verdict form, make sure that it's filled out appropriately and that it constitutes the true verdict reached by you all. And today's date, today is January the 29th. Presumably you'll reach a verdict today, but you may come back tomorrow, which is perfectly all right. But whatever date you do reach the verdict, you should fill out the date and sign it appropriately. Then when you come back in the courtroom, the foreperson should hang on to this verdict form, bring it in, and the bailiff will retrieve it, deliver it to me, and I will read into the record your own true verdict. Now, I can't give you any hint at all as how to decide this case. I can discuss procedure if you have any questions about deliberations in terms of mechanics or anything like that. Does anyone want to tell a joke that hopefully that I'm not the butt of? No jokes. Okay. Well, this is serious business, and I want you to get started and get down to business in this matter. We have all the exhibits there, Madam Clerk. All right, we have boxes of them somewhere. And ladies and gentlemen, I'm going to put this jury charge on top, and on the very top will be the jury verdict form, and the clerk will make sure that they are right there for your viewing and review. All right, members of the jury, you may follow the bailiff to your jury room and commence your deliberations. Okay. Permit me to thank all counsel in this case for your cooperation, your patience, and your consideration. It's been a pleasure dealing with all of you in this matter. This has been a trial of no serious problems or issues, and you folks have made it that way. You folks have been excellent to work with, and I express my sincerest thanks to all of you.
Thank you, Your Honor. Thank you, Your Honor.
Now, you can remain on the premises. If you wander away or go back to offices, give Sarah a number where she can reach you, because we'll need to gather quickly when the jury arrives at a verdict. Anything else before we start our verdict watch?
Your Honor, you didn't have to take this case. And both sides were so glad that we did, and we're really glad.
Well, thank you. I appreciate it. That means a lot.
And one of the reasons it went so smoothly is because of this court.
Thank you.
And we join, of course, in the sentiment.
Thank you very much. All right, we will notify you folks whenever a verdict is reached. third judge of the Circuit Court of Raleigh County is now sitting. All right, I am advised that the jury has a verdict. All parties are present and the defendant is here. I'll expect no outbursts when I read the verdict one way or another, and I will direct the bailiffs to escort anyone out who violates this directive. Are there any matters that we need to discuss before we bring in the jury and receive the verdict?
That's for the state, Your Honor. Thank you.
No, Your Honor. Thank you.
Bring in the jury. Madam Foreperson, has the jury reached a verdict?
Yes, sir.
Would you hand that verdict to the bailiff who will transmit it to the court? Would the defendant please rise? In the case of State of West Virginia versus Natalie Cochran, case number 23-F-343K, the jury verdict is as follows. We, the jury on the issues, joined unanimously find the following. The defendant is guilty of murder in the first degree. The verdict form is signed by Holly Rich, foreperson of the jury. It is dated 1/29/2025. There are no marks on the portion of the verdict form pertaining to involuntary manslaughter. Does the state wish to examine the jury verdict form?
No, thank you.
Does the defense?
No, Your Honor. Thank you.
You may be seated. Is there a request for the court to poll the jury?
Not for the state, Your Honor.
No, Your Honor.
All right. The verdict is received by the court and directed to be recorded. I'll ask the state to prepare an appropriate order in the premises. The court accepts the jury verdict and finds this defendant guilty of murder in the first degree. The defense will be afforded time to file all appropriate motions, and as we discussed earlier, we must have further proceedings concerning the aspect of mercy. I would like to do that right away, and perhaps to commence this afternoon. I can afford the defense or the state 2 hours to prepare, and we can go directly into the mercy phase.
Your Honor, as we pointed out to the court, we cannot have our witnesses prepared in 2 hours. Specifically, we anticipate calling the children. They are not close by at all. They're in school.
Oh. Well, Matthew. No. What? I can't hear you.
I've been corrected on that particular point, but we have to get in touch with our other witnesses. It will take considerable time to do that. We have to make sure they can get here, and we respectfully request to continue these proceedings and have the mercy portion sometime tomorrow.
What saith the state, Mr. Truman?
Your Honor, the state's prepared to go forward. We understand the defense situation. If they could proffer a number of witnesses they're going to have, that might be helpful. And if they can't start out today, then we defer to the court's judgment.
All right. Members of the jury, let me explain to you the circumstances. You have found the defendant guilty of murder in the first degree. There is another aspect that you must consider, and that is whether or not to afford to her mercy. If she receives mercy, she will be eligible for parole in 15 years. If she does not receive mercy, she will spend the rest of her life in prison. And that is a decision that you must determine. We must have a mini trial, so to speak, further proceedings for you to hear additional evidence in that regard and make a determination. You will have to return an trial, so to speak, further proceedings for you to hear additional evidence in that regard and make a determination. You will have to return another verdict in regard to that matter. So the upshot of the situation is you are not finished with your responsibilities. And it is perhaps unfair to start into this right away and to force the attorneys to proceed in this very critical and important part of the proceedings. So it is such that we're going to start up at 9 o'clock in the morning. And I hope you'll understand, and I hope that you will continue to be cooperative and patient and considerate, and proceed as you have already. You have been here promptly, and you have provided service as jurors in the manner expected, in the manner certainly I request. So here's the deal. I must still warn you and admonish you not to read anything, hear anything, talk to anyone about this case. And by anyone, I'm talking about your family members or friends, because tomorrow is another day insofar as you all are concerned, and we will proceed further in regard to the mercy phase of this case. So you're not done, and we need for you to come back. And you may be sad about that, or maybe you're okay with that. I don't see anybody throwing tomatoes at me yet. So hopefully you'll understand. We need to finish this out. We have much time invested in it, and we simply need to bring it to a conclusion. And I will need you back in your jury room at 9 a.m. I'll try to have a treat for you as a bribe for you to come back. And please follow my instructions. Don't watch anything on TV or see anything online. Again, for the purpose of this additional phase, I want you to have an open mind and to hear the evidence so you can make this additional determination. I can't tell you anything as to what you must do in regard to mercy, but if you have any questions about the procedure, or if you want to curse me, now would be the time to do that. I don't see any curses, and I don't see anybody complaining too much. All right, I will need you back in your jury room tomorrow by 9. Anything further before I let the jury go for the day from the state?
Not for the state, right?
No, Your Honor, thank you.
All right, you may follow the bailiff to your jury room, and I'll see you in the morning at 9 a.m. All right, we will start up for the mercy portion of this case in the morning at 9 o'clock. The defense will go forward first, sort of an unusual arrangement. There is no burden of proof, and it's sort of the wild, wild west, more or less. The court will be very lenient in terms of evidence to be presented. The only thing that I'm bound by is rules 401 and 403 of the rules of evidence. 401, of course, relates to relevancy. 403 requires the court to engage in the balancing to make sure that the probative value of any evidence is not outweighed by its prejudicial nature. Other than those restraints, the court can consider prior bad acts, the court can consider character, the court consider habits, almost anything that would be relevant and not unduly prejudicial to the defendant. So you are guided by that instruction, and we will start up for the mini trial in the morning at 9 a.m. Are there any questions or suggestions from the state?
Not for the state, Your Honor.
Anything from the defense?
No, Your Honor.
All right, court is in recess.
system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people.